Good afternoon. Welcome to the 7th annual Live from L, an opportunity for lawyers from the Office of the Legal Advisor of the United States Department of State to share their perspectives on international law with our audience here today at the George Washington University Law School, as well as an audience around the world participating through the World Wide Web. I'm Susan Carmanian, the Associate Dean for International Comparative Legal Studies here at the George Washington University Law School. GW Law is delighted to join the International Law section of the American Bar Association, as well as with the American Society of International Law, to once again co-sponsor Live from L. At the outset, I would like to thank a number of people who have made this possible. And the interesting thing is these are people who have been working with Live from L from day one. In particular, I'd like to thank my colleague, Ron Bettauer, who was formerly in the Legal Advisor's Office. And in addition to being a visiting scholar at the George Washington University Law School, is active in the American Bar Association International Law section. Sophie Wilmot and Renee Doplick of the ABA International Law section, and Mark Agras, Sheila Ward, and Wes Riss from the American Society of International Law all have been instrumental in making this possible. Further, none of this could have happened without the support of the Office of the Legal Advisor. And in particular, we extend our thanks to Paige Deborah, who has been instrumental in making this event possible. And of course, I'm grateful to the lawyers who are here today, and I will quickly introduce them, and also my colleagues at the George Washington University Law School. Over the past decade, and the past few years in particular, the South China Sea has been the focus of considerable activity that implicates international law. Whether it be issues concerning the 9-dash line or the environmental implications of artificial islands, the subjects have been many, and also some of them have addressed in the recent award between the Philippines and China. To discuss these and other issues, we're delighted to have with us three lawyers from the Office of the Legal Advisor. Richard Vicek is here. He's the acting legal advisor who has also served previously as the deputy legal advisor and the principal deputy legal advisor. Robert Harris, who is the assistant legal advisor, Office of East Asian and Pacific Affairs, who has devoted more than 30 years of his life to service at the State Department, and we have had the privilege of having Robert speak at the law school before. And then Oliver Lewis, who is an attorney advisor, Office of Oceans, International Environmental Law, and Scientific Affairs. We are going to hear from our guests from the Legal Advisor's Office, and after that, we'll have the opportunity to have a conversation. We will be able to take questions live from the audience here, as well as questions from those who are participating online. Please feel free to send your questions to livefroml2017@gmail.com. We are going to be receiving the questions. I have my iPhone here. I promise I am not surfing. I am watching the questions come in. We already have 3 questions, so we expect a lively discussion this afternoon. Again, thank you all for participating. Thank you so much for our co-sponsors, and in particular, thank you so much for the lawyers from the Legal Advisor's Office. We're delighted that you could be with us here today. And so now I will turn the floor over to Mr. Vicek.
I guess it's good afternoon. Bob Harris, Ollie Lewis, and myself, we're very happy to be here. We're going to talk about an extremely timely and significant array of legal issues relating to the resolution of the ongoing territorial and maritime disputes in the South China Sea. Before I move on, I should say that Bob and Ollie are quite expert in this area, and they have been sort of the spear point of legal diplomacy, if you will, explaining these issues not only within the U.S. government, but also to foreign interlocutors all over the world. It's appropriate that we meet today at the campus of George Washington Law School, because what we're about to try to treat in a very short period of time are an array of legal issues that are topics in any law school curriculum, or at least any law school's international legal curriculum. Topics range from customary international law relating to the acquisition of sovereignty over land territory, international law with respect to the law of boundary limitations, treaty law, the international law of the sea, and finally, the peaceful settlement of international disputes. Many in the audience will be familiar with the July 12, 2016 arbitral decision, and we'll spend a good part of this afternoon talking about that. It was constituted under the Law of the Sea Convention's compulsory dispute settlement procedures, and it involved the Philippines and China. Before plunging in, I think it would be useful to, using the wonderful slides we have, to talk a little bit about the geography, if you will, the features, the maritime areas that are the subject of these disputes and competing claims. And I should note competing claims that are brought by not just China, the Philippines, but Taiwan, Malaysia, Brunei, and Vietnam. So it is a very contested area. And we'll give a very brief discussion of some of the flashpoints and some of the history of the disputes between and among the claimants. And principally, we're going to be talking, with respect to the South China Sea, we're going to be talking about the Paracel Islands, Scarborough Reef, and the Spratlys. Now, the dispute over the Paracel Islands, as the slide appropriately notes, is China, Taiwan, and Vietnam. China took control of them in 1974 when its troops seized a South Vietnamese garrison in the Western Islands. Similarly, Scarborough Reef, which is about 140 miles from Manila, tensions flared up in the spring of 2012 when the Philippines intercepted about 8 Chinese fishing vessels. To put things in perspective, these are not vast land masses. The collective area of the Paracel is, according to the CIA World Book, about 13 times the size of the National Mall. So not a tremendous area, but and the Paracels are up in, as we look at the map, courtesy of my wonderful assistant, far left, the northwest corner, if you will. Scarborough Reef is towards the Philippines, and the Spratlys are down in the southeastern portion. And I should say that the Spratlys, the claims are by China, Taiwan, Vietnam, the Philippines, Malaysia, and Brunei. And again, not a large landmass, perhaps 7 times collectively the size of the National Mall, according to the CIA. There are the military of various nations stationed on a number of the islands. And I think one thing to bear in mind is that in the latter half of the 20th century, probably 1970s on, as international law developed, including the law of the sea, the concept of maritime entitlements and exclusive economic zones became better appreciated, as well as, in that context, the fact that there is very valuable fishing and potential hydrocarbon resources in many of these areas. I'll talk about some of the major events, if you will. And there's the Spratlys. I mentioned that in '74, China expelled the South Vietnam from the Paracels. Then note what's not on there, but probably should be, is 1982, the adoption of the Law of the Sea Convention. 1988, in the Spratlys, we had what was known as the Battle of Johnson Reef South between Vietnam and China. It was a fairly brutal battle. China had set up a survey station on what is known as Fiery Cross in that region, and near that area, and the battle occurred on Johnson Reef. In '96, also in the Spratlys, China occupies Mischief Reef. And then again, also in the Spratlys in '99, the Philippines places a naval vessel known as the Sierra Madre at Second Thomas Shoal, and you'll see a slide of the Sierra Madre later. And then in 2002, in an effort to basically address the growing disputes and concerns, the Association of Southeast Asian Nations and China concluded a declaration of conduct on South China Sea. It was non-legally binding, but in effect, it called upon the states to resolve disputes peacefully without the use of force in accordance with the 1982 Law of the Sea Convention, to exercise self-restraint from activities that would complicate or escalate the dispute, including not inhabiting uninhabited islands, and to explore confidence-building measures. It also indicated that they would work on a code of conduct. That work continues. And then back to 2009, you'll see the reference to the China Note Verbals, and Ali, I know, will talk at length about this in the 9-line map. Essentially what happened in 2009 is the PRC communicated 2 Note Verbal to the UN Secretary General in disputing other countries' continental shelf claims. The PRC asserted sovereignty over the South China Sea Islands and enclosed a map depicting 9-line segments, or what has become known as the 9-line. In 2012, I think I mentioned Scarborough Reef. We had the interception of the fishing vessels from China by the Philippines. And then in 2013, the Philippines brought the Law of the Sea Convention arbitration claims. And then shortly after that, in 2014, China engaged in, and to the date, engaged in fairly aggressive land reclamation. And you'll see that while land reclamation is nothing new and there's nothing inherently wrong if it's your land to reclaim, the size and scope of the Chinese reclamation has been beyond the norm, about the size of 3,200 acres, if you will, and the pace has been fairly aggressive. In 2015 and 16, as the slide notes, China built airstrips on 3 reclaimed features, Fiery Cross, Subi, and Mischief Reefs. And then, of course, finally in our list of big events, we have the July 12, 2016 decision in the Philippines-China arbitration. Now, the slide that we just had up there, move forward. Okay, this is Fiery Cross before reclamation, and you'll note that little white dot or speck down there in the lower left-hand corner. That, in effect, was what was above land, above sea prior to reclamation. And then to show how the neighborhood got gussied up, here is Fiery Cross today, complete with an airstrip. So a rather dramatic reclamation effort. So with that brief sort of factual setting, I'm going to turn it over to Bob, who's going to talk about the specific South China Sea legal disputes.
And Bob, if you could be so kind to speak into the microphone a little clearer. Thank you so much.
So
appreciate it.
It's green when it's on, right?
Yes.
Great. So you'll probably. Well, thank you, Rich. It's great to be here. It's always challenging to try to talk about a subject as broad as legal disputes in the South China Sea, given the huge range of issues that are on the table. But we'll try our best, and we'll try to do it in a way that will leave some time for questions at the end also. There are 2 categories of disputes that arise in the South China Sea. More than that, really, but the 2 fundamental ones are disagreements as to sovereignty over land and disagreements with respect to a range of maritime issues involving the international law of the sea. So to start with, what is the U.S. posture in the South China Sea? So even before I get to the legal disputes, I think it will help give some basic sense of what does the United States say. And I think nothing on this slide will be surprising. These are things that our press spokesman has been saying for many years now. But I think it's useful to hear because it will tell you the sorts of things that the United States focuses on and those things that we don't focus on. So first, on land claims. In keeping with our global policy, the United States takes no position on competing claims to sovereignty over land features. Ollie's going to talk about this more, but just remember, when we're talking about land features, it's a question of, is something in its natural state above water at high tide? If something is above water at high tide in its natural state, and 2 or more countries are claiming that it's theirs, we're not going to take a position on that issue in keeping with our global policy. Maritime claims, however, we do take positions on as a government, and maritime claims must be in accordance with the international law of the sea, as reflected in the 1982 Law of the Sea Convention Ollie will talk about that more. A national interest. The United States has a national interest in the South China Sea and, in fact, around the world in the maintenance of peace and stability, unimpeded lawful commerce, and respect for international law, including freedom of navigation. And finally, claimants should explore all diplomatic and other peaceful avenues and refrain from the use or threat of force in resolving their disputes. And for us, peaceful can include third-party dispute settlement if countries are unable to resolve their disputes through diplomatic means. All right. So what is the international law for resolving territorial disputes? We're going to go pretty light on this subject. As we've said already, the United States doesn't take a position on these issues, but you should know, since this is a legal discussion, that there is an entire body of international law, customary international law, on the question of resolving territorial disputes. What is it where countries have disagreements? There is a body of international law for resolving that. The cases are extremely complex. So deriving the customary international law can sometimes be challenging, and one of the helpful places to look are tribunal decisions or arbitral decisions where the two parties have submitted their dispute to third-party dispute settlement. And when you look at those cases, and there are a number of them, the theory that's most relevant in these kinds of, let's say, under-occupied features, as Rich suggested, in the South China Sea, especially the Spratlys, because that's what we're going to talk about for the lion's share of today's presentation, these features are minuscule. The largest feature in the Spratly Islands is Ituaba, a feature, an island that's occupied by Taiwan. It is less than half a kilometer in size. So we're not talking about very large features, and that is the largest by far of the islands in the Spratly Islands. So these are not the kind of islands that people put their flags on and then hundreds and thousands of people came and settled. We're talking about the international law for resolving a sovereignty dispute where probably no one has lived there. Or in the case of a few of them, maybe a few people have lived there, but very few. So what is the law that the tribunals look to? Well, they look to a display of authority, a continued display of authority by evaluating the intention and will of the state to act as a sovereign and some actual exercise of authority over that disputed feature. So the case that's often cited is the legal status of Eastern Greenland, 1933, but there are other cases, including some relatively recently, where courts and tribunals have looked at those issues at the request of the disputing parties. Now, this is a tricky issue also because this is what we would call a mixed question of law and fact. So not only do you have the question of competing narratives as to which country has shown a display of authority over a sustained period of time, but the tribunal must figure out what the critical date is. At what date did the dispute crystallize so that you can then say that is the date that we will evaluate which of these claimants has the better argument of displaying authority and control over the feature. And so any actions that a country takes after that critical date as a matter of law does not strengthen their position. So let's say a dispute over an island emerges in the year 1797. Well, at that point, whatever actions the two sides take doesn't strengthen their claim. So even if one side occupies the feature, that wouldn't, under this analysis, improve its legal position. Anyway, so that's what's a critical date that people look at. And as I noted, these are very complicated areas. So that is the question of territorial disputes. I will now turn the conversation over to Ollie to talk about the law of the sea. But just remember one thing, that under the law of the sea, if you walk away from this presentation only knowing one thing, and we'll say it a couple times, just remember for purposes of the law of the sea that land dominates the sea. So if you want to figure out what the maritime entitlements are of a country, you first have to figure out what country has sovereignty over land, because it is the land that generates the territorial sea, the exclusive economic zone, and the continental shelf. So as a result, the maritime disputes have a basis in the underlying territorial disputes and are harder to resolve because the underlying territorial disputes remain unresolved. And with that, I will turn the clicker to Ollie.
Thank you so much, Bob, and I look forward to your comments and into the microphone as well. Thank you.
Thanks very much. And yes, as Bob said, it's a different body of law internationally that governs whether those maritime claims, which are derived from land and sovereignty over land features, whether those are lawful claims. And that's the international law of the sea, which has been around for a long time, and I won't bore you with the history of it, but it goes back hundreds of years, and the current sort of reflection of it is in the 1982 United Nations Convention on the Law of the Sea, which has been enforced since 1994, and has almost 170 parties at this point. The United States is not a party to the Law of the Sea Convention, pending Senate advice and consent. The policy of the United States government since President Reagan in 1983 issued an oceans policy statement to this effect is that the provisions of the Law of the Sea Convention reflecting traditional uses of the ocean reflect customary international law, which the United States will recognize and comply with as a matter of policy. So even as a non-party to the Law of the Sea Convention, the relevant rules that I'll be talking about reflect customary international law binding on all countries, and a non-party status is not relevant to that. The Law of the Sea Convention was negotiated over much of the 1970s and early 1980s, and is often described as a constitution for the oceans. It's meant to govern all uses and claims in maritime space, but in maritime space, not on land. So the Law of the Sea Convention itself does not govern the sovereignty disputes that Bob was talking about. It also comes with an elaborate dispute settlement mechanism that we'll be talking about in a little bit, which applies only to parties. So that would be an example of an aspect of the Law of the Sea Convention that is treaty law binding on parties, but is not reflective of customary international law, since under international law, states cannot be drawn into compulsory binding dispute settlement absent their consent. That consent would be reflected by joining the convention in this case. While the Law of the Sea Convention ranges very broadly over really all activities in the ocean, I'm just going to focus on a few here: the maritime zones you can claim, how maritime boundary delimitation works, navigational rights and freedoms, and the entitlements of islands. Just to touch on maritime boundary delimitation first, since I won't say too much more about it, the idea there is that if you have a lawful maritime claim, another country from a different bit of land, say there's no dispute even, may have also a lawful maritime claim, and it may overlap in a given area. So the law of maritime boundary delimitation is by what process and what rules do states decide where their maritime boundary is to clarify who's got rights or jurisdiction on in which particular areas, on which side of the line. Going back to what Bob was saying about the U.S. positions on all of this, if we're talking about lawful maritime claims, the United States doesn't take a position on where the countries should draw their maritime boundary. Under international law, that's for the countries themselves to agree on, so long as they do it in a way that doesn't impact the rights and duties of third states. It's up for those countries to decide where to draw their maritime boundary, or they could decide to arbitrate it, for example, or resolve it through third-party dispute settlement. So some additional key Law of the Sea concepts, as Bob mentioned: land dominates the sea. In the South China Sea, all maritime claims have to be derived from sovereignty over land features. And the Law of the Sea Convention also involved increasing attention in some ways to economic rights that I'll talk about in a little bit, as well as protection of the marine environment, the dispute settlement regime I mentioned, and other issues. The key idea is that there are different interests in oceans. Coastal states have interests in the activities that are happening off their shores. Maritime states have interests in their ships and being able to perform given activities, whether it's navigation or cable laying, pipeline laying, etc. There's fisheries, there's oil and gas, and all of these interests, it's a balance of interests reflected in the Law of the Sea Convention. between the interests largely of coastal states and those maritime states doing the maritime activities. So a quick 3-minute crash course on maritime zones under the Law of the Sea Convention. This slide is sort of a cross-section, and working from the left of the slide, all maritime claims are measured from the coastal baseline. That's usually the low tide line along the coast, and you can kind of think of it roughly as the legal definition of where the line is between land and water, from the Law of the Sea perspective. As far out as 12 nautical miles from the coastal baseline, a state can claim territorial sea. And the sovereignty of the state extends to the limits of the territorial sea, and actually to the seabed underneath and the airspace over as well. That sovereignty has to be exercised consistent with the Law of the Sea and other rules of international law. And so there are a few, you can think of them as exceptions to the way sovereignty applies on land. One of the main exceptions is the right of innocent passage. All ships from all states, whether commercial ships, warships, you name it, have the right to proceed continuously and expeditiously through the territorial sea, so long as it doesn't do one of a certain list of enumerated activities in the Law of the Sea Convention that affects the peace, good order, and security of the coastal state. So it's sovereignty like you've got on land, but you've got to let foreign flag ships pass through there in innocent passage. As you get farther away from land, the coastal state rights and jurisdiction diminish. So beyond the limit of the territorial sea, we'll ignore the contiguous zone, which isn't terribly relevant for present purposes. Out as far as 200 nautical miles, a coastal state can claim an exclusive economic zone. And this was not a concept that was sort of generated during the course of the 1970s and the negotiation, while the Law of the Sea Convention was being negotiated, as, again, a balance of rights and interests. The coastal state does not have sovereignty in the exclusive economic zone. It's got this more limited concept of sovereign rights and jurisdiction for certain purposes. Most relevant for present purposes may be the sovereign rights over the natural resources, fisheries, hydrocarbons, and the like for economic exploitation of the area. Insofar as the coastal state does not have sovereign rights and jurisdiction set out as reflected in the Law of the Sea Convention, the regime of the high seas applies, and that's what applies beyond 200 nautical miles from the baseline. And this was sort of the traditional rule of the ocean, the high seas, where the freedoms of maritime states apply. So the freedom of navigation, freedom of overflight, freedom of cable laying, pipelines, etc. Those freedoms apply both on the high seas and in the exclusive economic zone, except for things like the freedom of fishing, because the coastal state has rights over fishing in its exclusive economic zone. You've also got a regime that I won't get into for the continental shelf, which can extend out as far as 200 nautical miles, or under certain physical conditions even farther than that from the baseline. But that, in a nutshell, is the Law of the Sea Convention and the main zones. I think the territorial sea and the exclusive economic zone are sort of the key ones here, and it's the creation of the exclusive economic zone in the course of the 1970s and 80s that has led to an increased number of maritime claims in the world overlapping, because the rule before that was you had a 3 nautical mile territorial sea, and everything beyond that was high seas. Now, as coastal states can claim more, there are more overlaps, more boundaries to resolve. The navigational rights and freedoms I discussed. The only thing I would note is that, to reiterate, that the high seas freedom of navigation is one of the freedoms that does apply in the exclusive economic zone of a coastal state. The United States Freedom Navigation Program, you may have heard of, is a program that's been around since the late 70s, and it involves both diplomatic protests to countries of their maritime claims that do not comply with the Law of the Sea, and also operational assertions of navigational rights and freedoms, typically involving a U.S. warship sent through a territorial sea, for example, to demonstrate that the coastal state cannot require its permission or notification for such a ship to exercise the right of innocent passage, or that a coastal state doesn't have a security right, for instance, in the EEZ, its economic rights that it has there. Turning to the rules of islands, as Bob said, the the definition of island is reflected in Article 121 of the Law of the Sea Convention and is a naturally formed area of land surrounded by water and above water at high tide. So if it's above water at low tide but not above water at high tide, it's not land it's not an island as far as the Law of the Sea Convention is concerned. The effect of being an island is that the sovereign over that island is entitled to the same coastal zones that I just went through on the other slide as any continental land would get. So territorial sea, exclusive economic zone, continental shelf, etc. There's an exception in Article 121, paragraph 3 of the Law of the Sea Convention, somewhat opaquely worded, says in full what it says on the screen, that rocks which cannot sustain human habitation or economic life of their own shall have no EEZ or continental shelf. The idea there then is that such a feature would be able to generate an entitlement to a territorial sea and to a contiguous zone out to 24 nautical miles, but would not be able to generate an entitlement to an exclusive economic zone or a continental shelf. So it's been a big question in the South China Sea, where there are so many little features. First of all, which of those features count as islands in the tidal status sense? Are they actually above high tide in their natural state before land reclamation took place on them? Of those islands, which ones fall within that exception for rocks which cannot sustain human habitation or economic life of their own, such that they do not generate an EEZ and a continental shelf of their own? And that was one of the issues that the Philippines raised in its arbitration against China. The significance of the difference is pretty big, as you can imagine, just doing the math of pi r squared. If you have a little speck of an island that gets a territorial sea, its radius would be 12 nautical miles, and the area of maritime entitlements it generates for the territorial sea would be 442 square nautical miles around. Whereas if it generates an EEZ, you would add, over 125,000 square nautical miles to that. That's an area about the size of California, which can be generated by a small island capable of human habitation and economic life of its own. Interestingly, China has not always formulated its maritime claims, and still does not formulate its maritime claims, in these channels of the Law of the Sea Convention. And this all came to a head in May 2009 when, in the course of responding to some actions by other states, China submitted this note verbal to the United Nations, articulating its claims in the South China Sea. And you can see it's a mixture of language, like what I was talking about in the Law of the Sea Convention, where it says it has sovereignty over the islands in the South China Sea, and then language that's not Law of the Sea language. And the adjacent waters. What are the adjacent waters? That's not a defined term in international law. Likewise, enjoys sovereign rights and jurisdiction, very EEZ, continental shelf sounding language. But then it's over the relevant waters. Again, not a defined term in the Law of the Sea. And so there's quite a lot of confusion about what this means, which the three famous words sea attached map did not particularly help resolve, because the attached map, which you can sort of see on the screen there, is the 9-dash line, as it's often called, the dash line claim that China has, in which, digging up an old map from the late 1940s that it had generated, now publishing it internationally, without any description of what the dashes signified, what were the rights claims, what's between the dashes. In fact, the location of the dashes has changed over time if you look at different versions of the 9-dash line. But in some sense or another, it's been understood, and China's actions have seemed to imply in some way or another that China is claiming rights, maritime rights, in the South China Sea out to the full limits of that 9-dash line, the shaded area you see on the screen now. That shaded area, and we'll come back to this, does not line up with what is 200 nautical miles from the high tide features, the islands in the South China Sea or uncontested Chinese territory. So, as I'm sure you know, it caused quite a lot of consternation in the region. The U.S. position with respect to the 9-dash line is that, first of all, it was ambiguous and as such can't be a maritime claim, because it doesn't match the contours of what you could claim under the Law of the Sea Convention from the islands in the South China Sea. Prior to the Philippines-China arbitral decision last summer, China often was very ambiguous about what the 9-dash line meant, and is still to some degree ambiguous about it, but sometimes would say it was a claim based on historic rights. Or sometimes it has appeared to claim rights around wholly artificial islands or collective grouping of islands, right? That not just each island generates a maritime zone, but you can box islands the way you may remember the Paracel Islands on that first map were boxed, and that the line between the islands would be the baseline that you generate the 12 nautical miles, or et cetera, from, rather than each individual island. And all of those types of claims are not consistent with the Law of the Sea Convention. Historic rights have been superseded by the Law of the Sea as reflected in the Law of the Sea Convention, and so China cannot say that this area within the 9-dash line to its limits is a historic rights claims. Wholly artificial islands do not count as naturally formed areas of land surrounded by water, and so do not, under the Law of the Sea, generate maritime entitlements. Collective grouping of islands does not comply with the rules under the Law of the Sea Convention for where you can draw the coastal baseline from which you measure the breadth of all your maritime zones. These views, especially on the historic rights and possible other interpretations of the 9-dash line and whether it be lawful, we published in our Limits in the Seas series, which has been around for a number of decades. This was study number 143 in this sort of technical legal series, and basically came down and found that the 9-dash line could be lawful if all it meant was that China has basically drawn a circle on a map and said all the islands within this area we claim, but the maritime zones from those islands would be those determined under the Law of the Sea as reflected in the Law of the Sea Convention, and that the line itself, the dash line itself, didn't reflect a maritime claim. And that is how Limits in the Seas number 143 analyzed it. It's on our website, and I would refer you to it as a really good publication that I think is garnered wide acceptance in kind of the international community studying Law of the Sea and studying South China Sea in particular. Turning to the dispute settlement provisions in the Law of the Sea Convention before turning back to Bob, as I said before, states cannot be hauled into before a court or tribunal absent their consent under international law. China has not consented to resolving its territorial claims under any forum, but by joining the Law of the Sea Convention, it did consent to the compulsory dispute settlement process reflected in Part 15 of the Law of the Sea Convention. And so that is the way that the Philippines shaped its arbitration against China. So what does compulsory and legally binding mean? Compulsory just would be that the proceedings go ahead whether you like it or not. Once you've consented to this regime, even if you don't show up, they will march forward. Legally binding is the result entailed by that proceeding, that the decision of an arbitral tribunal's jurisdiction over a case is legally binding on the two parties to that case. The details I won't necessarily go into here, but they're on the screen for some of the provisions in the Law of the Sea Convention that make it clear that a court or tribunal could continue to decide a case. And interestingly, there's actually sort of a higher burden in some sense on a court that, or a tribunal that hears a case in which a party under the Law of the Sea Convention does not appear, which is that the tribunal itself must satisfy itself that not only does it have jurisdiction over the case, but that the claim is well-founded in fact in law. So it's not just like a default judgment, it's actually a considered burden on the tribunal. And Article 296 is the provision that provides for the legally binding effect of such an outcome that is binding on the two parties to the dispute. It's not binding on any other countries to dispute whether they're a party to the Law of the Sea Convention or not. It's binding only in respect of the particular dispute as well. So, Bob, back to you maybe to talk about the Philippines-China case in particular.
Great. And for time purposes, since we are only going to 1:30, we're going to try to wrap this up by 1 o'clock. Maybe it'll go over a few minutes, but to give enough time so that there's time for questions and answers.
Great.
So,
thank you, Bob. And we already have questions coming in, so those of you who are not here in the room, please feel free to email your questions to livefroml2017@gmail.com. Bob, the floor is back to you, and please speak in the mic.
thank you. Well, one of the challenges, of course, is I have about 20 minutes to talk about a decision that is very dense, both with respect to questions about whether the tribunal has jurisdiction to hear the case under the Law of the Sea Convention, and then the merits of the case, assuming that there is jurisdiction to hear the case. There have been 2-day conferences that have studied this decision at length. The National University of Singapore in January had a 2-day conference where legal experts from around the world came and parsed the jurisdictional issues and the merits issues. I will not have that luxury today, but I will try to give you an overview of some of the important pieces. The one thing that Ollie presented, everything that he said in his presentation on the Law of the Sea has relevance in the arbitration, which was why it was selected for Ollie's presentation on the Law of the Sea. So we'll be talking about concepts that you have just heard about. So at least there won't be major surprises. I think one of the pieces that I'll spend less time talking about are the jurisdictional issues. They're really very, very interesting, but in this case, we'll spend not so much time talking about them. I think one piece of paper that's somewhat interesting, if people would be interested in understanding China's legal position about jurisdiction in the case, would be to look at a position paper that it issued in December of 2014. And in that position paper, China made several arguments with respect to why it believed that the tribunal didn't have jurisdiction. And I'd say the 3 principal arguments would be that no matter how the Philippines styled the case or tried to describe the case, it's really an attempt to have the tribunal adjudicate issues of sovereignty. That's the first line of argument that China makes in its position paper. The second is that no matter how the Philippines styles the case, it's really an attempt to ask the tribunal to draw a maritime boundary delimitation in the Spratlys and elsewhere in the South China Sea. And the third is that the Philippines, in the view of China, entered into international agreements in which it committed itself to resolve disputes solely through diplomatic means and to not engage in third-party dispute settlement. That is, of course, a simplification, but those are the principal arguments that China made. Now, going back to what Ollie said, remember the tribunal under the Law of the Sea Convention has an obligation to, even if a party is not before it, to satisfy itself that there is jurisdiction over the case. And so for that reason, when the tribunal was looking at questions of jurisdiction, it looked very carefully at China's position paper. In fact, it treated it as a pleading in the case, as a formal submission, so that it would look at it very, very carefully. It also looked at issues not raised in China's December 2014 paper to evaluate whether China might be the beneficiary of other defenses that would be available to it on the basis of jurisdiction. So there are 2 awards. So when we talk about the decision, we're compressing 2 different decisions. In October of 2015, the tribunal issued an award, a lengthy award on the question of jurisdiction. And in July of last year, July 12th, it issued an even lengthier decision, principally on the merits, but also on jurisdictional issues that it hadn't addressed in its October decision. So to summarize these very, very briefly, the principal decisions on jurisdiction were as follows, and they're on the screen there, that China's non-participation was not a bar to jurisdiction. And they're looking at the dispute settlement provisions, the compulsory dispute settlement provisions of the Law of the Sea Convention that Ollie briefly described. They also found that the Philippines' decision to bring the arbitration was not an abuse of its rights under the Convention's dispute settlement process, that the case involved the interpretation or application of the Convention which is one of the requirements in the Law of the Sea Convention. In this case, among other things, determining the maritime entitlements under the convention. And here, just to help you understand this a bit, what the Philippines was saying in the maritime entitlements were we are a littoral state. We have uncontested land territory that is adjacent to the South China Sea. We accept the fact that there are these small features that there's a territorial dispute over. But from the Philippines' perspective, they should be allocated and allowed to enjoy the rights that they have under the Law of the Sea Convention to the extent that those rights don't overlap with the maritime entitlements of the disputed features. So that's in effect what the Philippines is asking the tribunal to do, saying, we don't ask you to say who has sovereignty. You don't have the authority to rule on that. But whoever has sovereignty over these islands, they're only entitled to so much maritime entitlements, not so much maritime entitlements. And that is the question of whether there is an issue involving the interpretation or application of the convention in maritime entitlements that the Philippines is arguing in its case. Also, the tribunal found that the case as a whole was not an effort to delimit maritime boundaries, thus falling within a declaration that China made under Article 298(1) of the convention. That's a provision that says there are provisions, as we noted, on maritime boundary delimitation, but there's also a provision in the convention that allows countries, when they become party or afterwards, to decide that disputes involving those maritime boundary delimitations will not be subject to compulsory dispute settlement. And that is a declaration that China and many other countries have made under the Law of the Sea Convention. So the tribunal had to figure out, well, is this case involving a maritime boundary delimitation, or is it not? And in this case, they found that much of the Philippines case did not involve delimitation of maritime boundaries, and therefore it would not be barred on that basis. And they also found, after reviewing the relevant documents and instruments, that the Philippines had not agreed to any international agreements barring them from compulsory dispute settlement under the Law of the Sea Convention. So, now going to the July 12th award. And what I'm doing now, I will be telling you what the tribunal said. So from this point on, I'm just simply recounting what the tribunal said in its July 12th decision, oversimplifying like crazy given the amount of time that we have. But according to the tribunal, in its decision on the merits, it found, first, that the 9-dash line is an invalid maritime claim to the extent it exceeds the entitlements set out in the convention. In effect, what it's saying is that the Law of the Sea Convention is the exclusive basis for countries in the South China Sea to set out their maritime entitlements. And to the extent that China had a claim that would exceed those entitlements set out in the Law of the Sea Convention, they would not be consistent with the convention. So that's the first piece. And a piece of that is that claims to historic rights beyond the territorial sea are superseded by the convention, and that the historical facts in the South China Sea would not have supported such a claim by China in any event. I would say generally that this analysis is roughly similar to what the United States stated in Limits in the Seas 143. Obviously, it's different. They're looking at it from a slightly different perspective, but the two approaches are relatively consonant in terms of analysis. There's another question, the award maritime entitlements and baselines. Now, we're not going to spend a lot of time on this, but one of the questions that the tribunal looked at was, how do you draw baselines in the Spratly Islands and potentially in Scarborough Reef as well? And the tribunal looked at the question. Remember, baselines are where land ends and the sea begins. And so from the drawing of baselines, that can have a huge impact on the actual scope of maritime entitlements. And so it looked at the Spratlys and determined that in drawing baselines, the Philippines and China could only draw baselines from each feature. You could not lawfully, under the law of the Sea Convention, for reasons set out in the slide that I won't get into, you couldn't draw a baseline around all of the Spratlys or all of the South China Sea. That would not be consistent with the provisions in the law of the Sea Convention on the drawing of normal baselines or archipelagic baselines. Under the law of the Sea Convention, only archipelagic states are entitled to draw archipelagic baselines, and China and the United States and other countries which may have archipelagos geographically that we have sovereignty over are not able to avail themselves of those provisions in the law of the Sea Convention that are available only to archipelagic states.
Just to clarify that point quickly, archipelagic states being a state made entirely of islands or parts of islands.
So, maritime entitlements from features. This is one of the areas, because it's particularly interesting and particularly relevant to the disputes in the South China Sea, that we'll spend a little bit of time on. One point, and this goes back to the burden on the tribunal to make sure that it was getting things right under the convention. It was nervous, I think, about accepting the word of any single claimant in a case. No matter how honorable a country is as a tribunal, I think the tribunal said, you know what, that's great. The Philippines have brilliant geographers. They're going to give us information, but we have an independent obligation to make sure that the information we're receiving and evaluating has been tested by other experts. So it appointed an independent expert hydrographer to advise it on technical questions. And based on that consultation with their own expert, they made a number of determinations. The first is having to do with low tide elevations. Remember, the question of whether a feature is above water at high tide is a technical one. And we're talking about very, very small islands that throughout much of recorded history, mariners were marking simply to avoid running into them. But because they're not occupied, the technical information that's available to them is sometimes subject to debate. So even within the United States, with a huge group of people that figure these things out, there are some features in the Spratlys that we have a medium confidence in our findings. So the tribunal really had a technical issue ahead of it to figure out which features in the Spratlys were above water at high tide. And it found that 5 Spratly Island features are not naturally formed areas of land above water at high tide, and thus don't generate their own maritime entitlements. The next piece has to do with rocks. And the tribunal found that Scarborough Reef, remember that small feature that's up near the Philippines? And all of the features in the Spratlys, that none of them were entitled to an exclusive economic zone or continental shelf. It found, in effect, that all of them, including Ituaba, and that was one of the questions. Ituaba, as we said, is the largest natural feature in the Spratlys. And there was sort of in the academic world some ongoing discussions among academics. They said, how do you think they'll decide on Ituaba? Do you think they'll decide that Ituaba is a rock, or will they decide that it wasn't a rock? Well, they evaluated the question based on the somewhat opaque language in the Law of the Sea Convention, Article 121.3, and found that none of the features in the Spratlys was anything other than a rock. All the features that were above water at high tide were rocks. And then, having then made the determination that all of features in the Spratlys were not entitled to more than 12 nautical mile territorial seas, then made the finding that all of the water areas that were within 200 nautical miles of uncontested Philippine land territory were within the Philippines' exclusive economic zone and continental shelf. To give you a sense of what that means, and we won't go into what the tribunal said on 121.3 because it's quite complicated and I think it will take over our time. But let's talk about the effect of what they said on the maritime entitlements. This, as you've seen before, is a picture of the 9-dash line. To the extent that there was a claim to historic rights in that area, there would be some kind of perhaps undefined, unclarified maritime rights that China might be claiming within the boundaries of the 9-dash line. This is what these areas would look like if all of the features in the Spratlys and Scarborough Reef generated 200 nautical mile exclusive economic zones and continental shelf. What you see is that because of that principle of projection, remember the state of California, that covers a lot of area. And if you look at this, were all the features entitled to EEZs and continental shelf, you probably have about 95% of the area within the 9-dash line within an EEZ or continental shelf of whichever country had sovereignty over those contested features. If Ituaba and only Ituaba were entitled to an EEZ and continental shelf, this is what, see that circle there? The others is the area up near the carousels. Since that was not part of the case, those were just drawing 200 nautical mile EEZs and continental shelves. That's not taking a position. It's simply talking about the scope of the decision. So if Ituaba were determined to be entitled to an EEZ and continental shelf, that would be the maritime entitlement of someone, whoever had sovereignty under the Law of the Sea Convention. And then the last slide is what the tribunal actually found. What it found was that all of the features in the Spratlys were entitled to only 12 nautical miles territorial seas. Now, Ali, this might be a good time for you to go down, because remember we've got that chart that really should sort of end when you get to the bottom of the Philippines. What you see is all the water that is near the Philippines, that's now in light blue, is within 200 nautical miles of the Philippines, and thus found by the tribunal to be the Philippines EEZ and continental shelf. That's what that little purple dotted line is. Now, the rest of the purple dotted line, when you get past the Philippines, is simply a thought exercise. That's not what the tribunal made no ruling at all with respect to the maritime entitlements of Malaysia or Brunei or Vietnam or any country that wasn't before it. One of the important things to remember is that under the Law of the Sea Convention, the decision is legally binding, but only on the parties to the case. But this shows you the effect of the maritime entitlements as determined by the tribunal in this case. So that gives you a sense of what the tribunal ruled. It also had findings on wrongful exercise of authority by the government of China. And this was particularly relevant in those areas that it just determined to be within the Philippines exclusive economic zone and continental shelf. Remember, the EEZ and continental shelf grants the country exclusive rights, exclusive and sovereign rights. So that means if you have exclusive and sovereign rights, other countries don't have rights and can't regulate in certain areas, in those areas in which you have those rights. So in those areas determined to be within the Philippines EEZ and continental shelf, the tribunal decided that certain Chinese actions were unlawful, interfering with Philippine petroleum exploration, attempting to regulate foreign fishing, failing to prevent Chinese fishing, and constructing installations in artificial islands. According to the tribunal, China also unlawfully interfered with traditional fishing rights of Philippine fishers at Scarborough Reef, rights also enjoyed by traditional Chinese fishers in the view of the tribunal. That's its own hour-and-a-half presentation, and we won't get into that. That's a separate body of law under international law that's related to the law of the sea, but is separate in some respects. Protecting the marine environment. The tribunal also found that certain actions by China were inconsistent with China's obligations under the convention to protect the marine environment. Those were large-scale land reclamation and environmental damage that was caused by it, failing to exercise due diligence over harmful practices by Chinese fishing vessels, and failing to fulfill convention obligations with respect to cooperation and releasing environmental impact assessments. I think we'll move on. U.S. reaction. Remember at the beginning I talked about what's our position in the South China Sea? Well, having heard this, you probably won't be very surprised by how the United States reacted in the immediate aftermath of the decision. But these points are probably worth my saying, since we all work for the Department of State, and this is the Department of State's position on this. So, the United States strongly supports the rule of law and the peaceful resolution of disputes, including through arbitration. In joining the Law of the Sea Convention, the Philippines and China agreed to its compulsory dispute settlement process to resolve disputes. As provided in the convention, the decision is final and legally binding on the Philippines and China, and that the United States expresses hope and expectation that both parties will comply with their obligations. The United States urged all claimants to avoid provocative statements or actions and use the decision as an opportunity to resolve disputes peacefully. And finally, we encouraged claimants to clarify their maritime claims in accordance with international law as reflected in the Law of the Sea Convention. We'll have just a quick moment. Ollie, why don't you take us through the last little bit of the denouement or the coda on the Law of the Sea and this decision.
Sure, thanks. So that's what the United States said in the immediate aftermath of the tribunal's decision on July 12th. What China issued within 24 hours of the tribunal's award was a series of papers, a statement from its government, a statement from its Ministry of Foreign Affairs, and a so-called white paper laying out some of its arguments, which for the first time involved a new formulation of China's maritime claims in the South China Sea. And for the first time, that formulation unambiguously asserted historic rights in the South China Sea. It's very ambiguous about what exactly those rights are, where they are, whether they're intended to be exclusive rights or what. But the fact of asserting historic rights was no longer an ambiguous question. It was very clear. And among other claims, China also noted that it has internal waters based on, my pronunciation would be terrible, but non-haijudao, which is China's term for sort of the collective South China Sea islands and the various groups of islands within the South China Sea. And in addition, China also claimed territorial sea, exclusive economic zone, continental shelf, and the Law of the Sea framework for maritime rights as well. But these claims to historic rights and internal waters based on those island groups, the United States issued a formal diplomatic protest to China about saying that they're not consistent with the international law of the sea. And this is, as I mentioned in the Freedom of Navigation program earlier, this is something we do to countries around the globe, regardless of how warm and close our relations are with the countries. We seek to ensure that all maritime claims by all countries are compliant with the international law as reflected in the Law of the Sea Convention. And we often publish our diplomatic protests in that regard in the digest of U.S. practice in international law each year, and you can look forward to seeing our protest to China published there. And in addition, the other part of the Freedom of Navigation program on the Department of Defense website, they publish what countries they have done operational assertions, Freedom of Navigation Ops or Foreign Ops as they're sometimes called, against excessive maritime claims, i.e. claims that do not comply with the international law of the sea as reflected in the Law of the Sea Convention. Rich, back to you.
Yeah, and I think one thing to just emphasize is that I should speak closer to the mic, but is that U.S. legal positions in the South China Sea, they're not tailored to the South China Sea. These are long-standing positions that we've held, and it's a global approach. We believe in freedom of navigation, all the principles that Bob and Ollie sort of went through. It could be the South China Sea, it could be the Atlantic Ocean. But how people think about these disputes is very much informed by the international legal framework and international law in this area. And obviously the desire to settle these disputes peacefully. So we're fortunate in that within the Office of the Legal Advisor, we have Bob and Ollie who have developed such expertise in this, such that they can help explain these principles and the law to policymakers, and also engage as part of the public diplomacy effort to sort of explain the issues and the handling of these issues under international law, not only to within the U.S. government, but to foreign governments, academics, so that there's a promotion of a better understanding of the contours and the content of the law regarding these disputes. So with that, I will turn it back over to Susan, who will tell us about all the questions we have
Great.
generated.
Well, first, let's give a round of applause for what I think is an outstanding presentation. We've had a number of questions come in via the internet. The first one that came in was actually before the session, and Rance Allman is here. He's a partner at the Wix Group, but also he contributes to The Diplomat, which is a foreign affairs journal covering the Asia Pacific. I'll just paraphrase your question. If I get it incorrect, please feel free, Rance, to chime in. But he and Bob, this may be a question I think suited for you. He notes that the tribunal was careful to preserve its jurisdiction and specifically try to avoid issues of sovereignty and maritime delineation. Yet the analysis of the tribunal perhaps impeded China's claims of sovereignty and territory in the South China Sea. And so his question is what does this mean for international law? Was it well served? Was it well used in this dispute? Perhaps there were other ways to address the jurisdictional issue.
Yeah, it's an interesting question. I should turn this on. I mean, I guess there's two different things going on there. About once you're dealing with the jurisdictional issue, you're already in the arbitration. So to some extent, the question is, was the Philippines wise to pursue an arbitration? And that may be, is that the question sort of, or is it more?
Well, I think that with China's non-participation and an ultimate rejection of the PCA award, it comes down to in this situation. You kind of stated the assumption that if you frame the argument, you might get the result. And I thought that the Philippines brief was devastating in this logic, and I think the PCA adopted that logic. But I think from the Chinese viewpoint, they saw the argument starting on a different end of the continuum. And so where you start that argument, where you start that legal analysis really matters. And so when they were saying, well, this is really about sovereignty, and whatever decision you make is really going to impact our sovereignty claims, I think that's, in a way, that's perhaps a valid argument. I'm not a complete expert on the law of the sea, but I'd be interested to know if there was an alternative on the jurisdiction, a credible alternative on how you might interpret that issue.
Well, I mean, I think the tribunal was looking what any tribunal would do with respect to a convention that gives it very specific guidance as to what jurisdiction it has. And it has to really carefully evaluate the language in the convention to determine whether it has jurisdiction. So in this case, one of the key issues is whether there are issues involving the interpretation and application of the convention. That language appears 5 or 6 times in those provisions, and that's sort of the key, is to say, okay, well, is there in fact one of those kinds of questions that I'm being asked to look at? And I think that's why I made that point about the Philippines perspective, which is we have rights under the convention from our uncontested land, and we're not able to enjoy those rights because of the contested land's maritime claims that might exceed the entitlements under the law of the sea convention. And so I think that's the approach that the tribunal took, which was, well, what are the entitlements of China and the Philippines under the law of the sea? Well, it seems like if the law of the sea convention did one thing, it was to help countries understand what their maritime entitlements would be. So I think that's certainly the logic that the Philippines took, and it certainly seems like the approach that the tribunal took, which was, we're just simply doing our job here. We're simply making sure, asking and answering the question of what do these provisions in the law of the sea convention mean. I wouldn't try to evaluate whether it was an A+ or an A- or whatever, but I certainly think that was the approach taken by the Philippines and the approach taken by the tribunal.
Great. Thank you. The next question comes from Paola Eisner. She's a student at the Harvard Law School, class of 2019. And Ali, I think this would be a good one for you since you touched on a little bit of this. First, she'd like to thank the panelists. And then specifically on the historical precedent of treating natural versus man-made accretion and erosion that have changed island features in particular? And does zoning automatically shift with the natural features or the actual situation on the ground, or is there another process?
Thanks very much for the question. So, under international law, as I said, the question for whether something is an island is whether it's naturally formed or not. So when you look to whether it is above high tide, you look to whether it is above high tide in its natural state before construction or land reclamation on top of it. You have a right under the law of the sea in certain contexts to build artificial islands, but the provisions for artificial islands don't allow them to generate any maritime zones of their own, maritime entitlements of their own. You only can do a 500-meter safety zone around it to help in terms of avoiding collisions and safety of life that the coastal state can have. Now, there is one little wrinkle, which is that as you build harbor works or other land reclamation on a coast, it can change where the baseline is located from which you measure the breadth of your maritime claims, but it doesn't change whether you can claim a territorial sea at all. So if you look to a state like the Netherlands, which is largely reclaimed land, their coastal zones would be measured not from where the North Sea ended 200 years ago, but rather from where the North Sea ends now. I hope that answers the question.
Yeah, I believe it does. I see we have one question in the audience. Let me just take a question that was emailed in from Charles Crumpton in Honolulu, Hawaii. Thank you, Mr. Crumpton, for waking up early and watching us. And this is more of a broader policy question. But we've heard about the number of states that are affected by the activity in the South China Sea. And Mr. Crumpton asks, what alliances of nations or organizations may be constructive and realistically achievable to foster a fair and just allocation of responsibilities and benefits to maintain, protect, cultivate, and share the territories and resources of the East Sea, the South China Sea, consistent with the law of the sea, rule of law, and peaceful international relations. And obviously we have an arbitral award out there as well, and maybe that fits into the objective. I don't know. But Bob?
Do you want to?
Yeah, I'll start, and Bob, you fill in what I don't capture. Obviously we do have the Law of the Sea Convention and the Arbitral Award. We also have, ASEAN, which has played a role in promoting peaceful settlement of disputes in the past, and hopefully will continue to do so. And then certainly there's the importance of bilateral efforts, and that's not just, bilateral as between disputants, but it's obviously a role for other countries around the globe to play to reinforce sort of their view that these disputes should be settled peacefully. And with that, I will see if Bob has any additional thoughts.
No, it's complicated. Obviously, under the Law of the Sea Convention, the state that has sovereignty over the land feature has maritime rights. So, there's, in figuring out what to do in that space, the countries that have, the littoral states and the countries that are claimants will have, once they resolve those territorial disputes, certain rights that will be more important in many senses than other countries' rights. But I think the larger question is, how can the international community help support these efforts? And I think ASEAN has gone a long way itself in creating a platform for negotiations, because not all ASEAN countries are claimants, but it's an important part of ASEAN countries that are claimants. And so that is what I would call plurilateral diplomacy. There's obviously global multilateral diplomacy, and all countries that are following the law of the sea are part of that constituency. So I think it's a question of trying to have different concentric circles all work together to try to help the claimants find a peaceful solution to the problem.
Thank you. My name is Jeannie Nguyen with Voice of Vietnamese Americans. The question to follow what you just said is how to support ASEAN in promoting the decision of the PCA to make sure that the international law prevails not only in the South China Sea, but globally. So to what extent do you think the U.S. and the international community can support to be, especially with the militarization of the area, the use of economy coercions in the area, and they are about to have a discussion, hopefully, between all the claimants and China. And ASEAN chair this year is the Philippines. Would you speak for that effect? To what extent can we use the PCA and support that? Thank you.
Well, I guess I'd start by saying you're looking at three lawyers here. And it is true that we do work closely with our policy offices. We have a senior official from our Bureau of Oceans, Environment, and Science here today. We work very closely with the Bureau of East Asia and Pacific Affairs. They have an office that works directly, multilateral affairs, that works with ASEAN. We support those diplomatic and policy efforts. I wouldn't want to get too far ahead and into someone else's lane here. But having been in the room, I think we certainly, as a government, have tried to support all peaceful efforts to resolve the disputes consistent with international law, and that's something that we do as a general matter, and ASEAN has been doing very good work in this area that we've been supportive of. How exactly that diplomacy will work over the next year, I think, is a question I'm not really competent to speak to, but it is certainly within the bounds of our policy to try to be supportive of efforts in the region to try to resolve the disputes peacefully. I don't know, anything? Anybody want a different dodge?
Yes, thank you.
I can follow up with the militarization.
With respect to militarization, well, the United States has made statements with respect to militarization. We've called on the claimants to avoid further militarization of their features or further land reclamation. So we have a policy that we've stated in that direction. I think if you go to the State Department's website for public affairs, you'll see the statements that we've made on encouraging countries to avoid militarization or further land reclamation or building new facilities on disputed features.
Thank you. My name is Ta Yukishima, Professor of International Law at Waseda University, Tokyo, Japan. I have a question. My question is the following. How do you evaluate the real and actual impact of the U.S. freedom of navigation operation or program upon China's attitude and the peace and stability of the South China Sea? Do you think that China has changed its attitude towards the other countries in the region, or do you think the South China Sea has become more peaceful after that? Thank you.
I think this, to echo Bob's earlier point, we're just the three lawyers. So in terms of assessing how China, whether this has impacted how they, what the actions they take in the South China Sea or not, I think that would be a bit of speculation on the part of the legal community here, but and I'm interested in Ollie's and Bob's views, but certainly the United States believes in maintaining its legal rights, and that includes freedom of navigation, both in the South China Sea and elsewhere around the globe. And again, going back to the earlier comments, we are also trying not to, we want parties not to take provocative actions, act within their rights, and try to resolve disputes peacefully. I realize that's a rehash of what we've said earlier, but I think from a legal perspective, we are rights-based. So.
I think that's exactly right, and also that the Freedom of Navigation program isn't asserting U.S.-specific rights in any way. It's a global program applied with respect to all claims by all coastal states, but also asserting the rights, freedoms, and lawful uses of the sea that all states enjoy, and ships from all states enjoy. And in that sense, as a global program, speaking generically, I think
My name is Chu Cai, and I'm an assistant professor of international law from National Taiwan University. And my question is about the regime of the islands in the law of the sea. So what might be the impact of the award has on the regime of the islands from your point of view? And especially in terms that state practice, because there are still several states claiming EEZ and the continental shelf from maritime features even much smaller than Ituaba. So do you think that those state practice will undermine the rules of the award, or those awards, or the rationale of the award will undermine the state practice? Thank you.
Thanks for the interesting question. Yeah. Well, the award is binding on China and the Philippines, and with respect to the features in question. So I don't think there's a question of undermining that. That's been decided. I take your question to be what will be the effect of this award in terms of other features, other claimants, other situations around the world. And in that regard, I don't have a crystal ball probably any more than you do. I have heard other commentators raise the question you raised about state practice, which is something that the tribunal did not focus particularly on at all. And circumstances where countries have claimed maritime rights or acquiesced to maritime rights or not objected to maritime rights and the like. And so I think we will see how the doctrine plays out. This was the first case ever in which an arbitral tribunal analyzed in any depth that provision on rocks which cannot sustain human habitation of economic life of their own. And so in that regard, it may be influential, and we'll see how countries react.
And if I could follow up with a specific question from Monica Heenan. She is a third-year student at Whittier Law School, and she has asked, have the Philippines, Vietnam, or any of the other surrounding countries taken legal steps to limit China's control, and in particular here with regard to the Fiery Cross Reef?
Yeah. Well, I'm not exactly sure what they mean by taken steps. I mean, one of the questions would be, I think one reads the newspaper and one sees that there are tensions, that there are fishing fleets from various countries that are operating in the area. I'm not aware of any particular actions that are different that the countries have been taking than they were taking before. There are ongoing tensions, and occasionally they will flare up when a Coast Guard vessel comes into contact with a fishing fleet from another country. But I don't think things have. I think most people would say in the months after the award, things have been calm, relatively calm in the waters of the South China Sea and the contested areas.
Okay. Thank you.
Hi, I'm Suyash Palawal with the Federal Reserve Board. Thank you very much for your discussion. I'd be interested to hear your thoughts on how the U.S. posture on this issue has changed under the Trump administration, and whether, how international legal considerations might factor into the administration's views. Thank you.
I think the presentation you received today is very much the presentation we would have delivered a month ago, which is very much the presentation that Ollie and Bob have been delivering for some time now. I think, again, it's a long-standing global approach to these international legal principles.
Good afternoon, I'm Jelly. I'm an international LLM student and I'm from the Philippines. My
question is, just today, our Secretary of Department of Foreign Affairs, and I quote in the news, said, "My position and this position and the position of the government and legal position is that the disputed territory in South China Sea has never been adjudged to belong to any particular country, and that this will be determined by another tribunal," unquote. So what do you think is this another tribunal that is being referred to by our Secretary of Foreign Affairs? And second is, moving forward, what do you think should the Philippines do with respect to this decision? Because right now, the government is conducting bilateral talks with China, and our president is being criticized by, in our country because of his actions, saying that he is not actually implementing the decision. So, any opinion?
Well, I think on the question of sovereignty, it will really be for the countries that have the competing claims to figure out how they will resolve that, which of course could include going before a tribunal and asking a third party through some process. It could be binding, it could be conciliation, it could be any number of options that may be available to them that they would agree to between or among themselves. So I think your foreign minister is in the best position to understand what he means by that and what some of those options are. I think anybody not part of that could only speculate. But it will, of course, be for the claimants themselves to figure out how to peacefully resolve the dispute, including potentially through some form of third-party dispute settlement. The other question was, what was the other question?
What should the Philippines do?
What should the Philippines do is another question that your foreign minister is really in the best position to. I mean, I think just to think back. I mean, look at what the decision said. The decision said that the Philippines have certain sovereign rights and exclusive jurisdiction in particular areas. Well, within those areas in which the Philippines was found to have sovereign rights and exclusive jurisdiction, it has pretty wide latitude to decide what it does in those areas. And as an exercise of that sovereignty and its jurisdiction, it's in a pretty strong position to decide what it does. I think as far as what kind of advice, I don't think this is a perfect spot, for us here to be offering any particular advice to the Philippines.
And it's interesting, Superior Court Judge retired Deanne Wilson had a somewhat similar question to the question of what is going to happen with the Philippines and China after the award. But it plays in well to a question, and this will be the last one, from Anne Laporta, who's a lawyer, and she's in the audience, but she kindly gave me the question in advance. And that is given the demise of the TPP, the possibility of some of the Southeast Asian states joining in with arrangements with China, the Regional Comprehensive Economic Partnership, could there be some condition to admission in terms of giving up potential claims in the region? And how is this going to affect the United States? Are we going to at some point be in a position of going it alone to protect the right of free passage?
I guess I'm the lucky one. Well, obviously, whenever you're dealing with multilateral arrangements, there's a lot of unknowns. Whether we're going to go it alone on respecting and advocating for the principles that undergird sort of freedom of navigation and the law of the sea, I seriously doubt that. I think the law as reflected in the Law of the Sea Convention was developed and arrived at because countries around the world thought those principles were important. And I don't see, trade negotiations somehow diminishing the longstanding importance of those principles. Thanks.
Great. Well, with that observation, I would like to again thank our distinguished panel from the Office of the Legal Advisor, the acting legal advisor, Rich Bicep. Thank you so much for coming over, and Bob and Ollie as well for sharing the wealth of information we had. Thanks also to those who participated online and those in the audience, particularly with your questions. And I would also again like to thank my colleagues at the American Bar Association International Law Section, as well as with the American Society of International Law. Thank you very much. It's good fun when you get there. You know, I knew that you handled the press sections perfectly. I thought I was going to get along with you. Yeah. Well, there was.